All right, good morning, ladies and gentlemen. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's docket. When I call your name, please say present or here and raise your hand so I can acknowledge you for the docket. Corey Lee Bates. Donald Ray Bean. Nesby Harold Bostick. Stephen Flores. Wilbur Bear. Devin Key. Sean Kuntz. Hunter Tapper. Michael Reisner. Megan Bailey. Dakota Davis. Jimmy Gibson. Jimmy Douglas Gibson. Travis Skinner. Devontae Wright. Mr. Wright may be late this morning. We'll circle back and recall his case. Robert Sandberg. Here. Jason Hodebeck. Here. Joe Sanchez. Here. Cynthia Kane. Here. Marcus Fowler. Janice Alcalon. Or Janice, is it Janice? Sorry. Joshua Brown. Here. James Fields. Here. Melba Kennedy. Philip Smith. Thank you, Mr. White. Amanda Tompkins. Thank you, Mr. White. David McLaren will be at 11. Jacob Howe will be at 11. All right, ladies and gentlemen, I'll just remind you that we are kind of in a crowd today, so I encourage the use of masks. You don't have to wear them, but I would strongly encourage them, especially while you're in the courtroom. If you do not have a mask and you would like one, you can let my staff know and we will get one for you. Make sure you stay spread out as much as possible. Make use of the entire courtroom. Be mindful of your distance when you're in the courtroom, the hallways, the stairwells, elevators, so on and so forth. And I would appreciate your assistance in doing that. Mr. Files, clients, Mr. Bear and Mr. Key and Mr. Kuntz. Do you need to see Mr. Bear on pretrial release? If you three will come forward and just meet with the pretrial release department, if I called your name. Wilbur Bear, Devin Key, Sean Kuntz, and Hunter Tapper. If you'll all just come forward and meet with the pretrial release department over here, then you'll be free to go. The state and defense have agreed to a motion for continuance, and those have been granted. All reset to May 25th. What, sir? What did he tell you? Okay, well, no, I want you to meet with him first, and if he doesn't need you, then come back out here and we're going to sign a notice of appearance for him. Okay, so just have a seat over here real quick, and Rachel, you do me a favor. Will you give me some more of these? Joe, just throw it up there. Thanks, sir. You guys don't need to see Mr. Bear. We just have Mr. Bear sign it, give him the yellow copy, and then you can go. Yes, sir, you're free to go. Sorry about the confusion on that. I'm gonna put a couple more here for Carl. So whenever these three having them sign pre-trial release conditions, if you'll just have a sign right there, give me the other copy. Bring me the white ones, so you can get rid of all those. I don't know where they're keeping I usually just, I don't really know where they go. Where you put those, Joe? To the, yeah, underneath that box there. I got one more for you. So once he's done with them, they're free to go. Mr. Bostic, if you'll make your way to the center podium, Ms. Beasley. All right, this is cause number CR 2284, State versus Nesby Harold Bostic, set for pretrial today, Ms. Beasley.
Yes, Your Honor. I would ask for an additional pretrial setting in order that I may discuss the case with the prosecutor and hope to resolve this.
Do you have any contested pretrial motions?
Not at this time, Judge.
Have you received all your discovery to your knowledge?
To my knowledge, yes.
Okay, so what the court will do is the court will set it for docket call and give you that time to meet with the state and continue your negotiations. Are you available on May 25th? Or let's do May 27th. Are you available on May 27th, Ms. Beasley?
I will take
Either one of those. If you have a conflict on one, we can do the other.
the 27th, Judge.
The 27th? Okay. Then let's set Mr. Bostic then for docket call on May 27th. And before you leave, Mr. Bostic, I need you to meet with pretrial release so you can sign your conditions of pretrial release and you'll be free to go. So maybe just clean that back. Mr. Schmidt, are you ready? Are you ready on? Jason Hodebeck, CR 2121. All right, Mr. Hodebeck is set for arraignment today. Have you had an opportunity to review the indictment with him?
Sir, we discussed the case, understand it was charged with,
All right, the court will enter Mr. Hodebeck's plea of not guilty into the record, and we will set this for pre-trial hearing. Any conflicts on May 27th? Yes. Mr. Hodebeck set for pre-trial on May 25th at 9 a.m. Before he leaves, Mr. Schmidt, Mr. Hodebeck, I need you to report to pre-trial release to sign your conditions of pre-trial release. So once you get the yellow copy, then step on back here with Ms. Burns. Is that all you have, Mr. Schmidt? Mr. Y, Mr. Ashmore, Ms. Beasley, any of y'all got anything that's ready? Ready? Everybody's ready? Let's rock, paper, scissor it. All right. We'll go ladies first. Ms. Beasley.
Flores, Your Honor.
Stephen Flores, CR 2211. All right, I show that we are set for status and plea today. What's the announcement?
Your Honor, we asked for one additional setting to set it for plea. My client, the reset was due to him trying to get a medical test. He's not been able to get that. And I'm explaining that we can't keep resetting forever for him to get that test. So I asked for one additional setting and set it for plea. We'll do it at the next court session.
Any objection?
The state has an objection, Mr. Flores have already executed a waiver of jury trial in this cause, so because of that, there's medical issue, we're not in office.
I appreciate that reminder, Ms. Heisel. All right, Mr. Flores. I'm gonna bring you back on April 29th. It's a couple of weeks. It's 2 weeks from today at 9 a.m.
Your Honor, could we set it on the May 27th that I've already set on? To get that medical test and get the results back. He is getting prison time. It's
Yeah.
not
I thought you just said put him on the next docket and you do.
well, my next docket for me is 27th.
Yes, so you went on the 25th or the 27th?
27th, Judge.
All right, court will set Mr. Flores to enter a plea before the court on May 27th.
Thank you, Your Honor. May I be excused, Your Honor?
Yes, thank you, Ms. Beasley. And Ms. Beasley, if you haven't spoken with Ms. Taberham today, will you speak with her before the afternoon? I believe that there's going to be an appointment for
I
you.
did,
Oh, you
Judge.
did? Okay.
I don't bill for permission to talk.
Yes, ma'am. Yes. Just know that their policy is that they don't. Yes, ma'am.
Thank you.
Thank you, Ms. Beasley. Mr. Schmidt, you ready?
I am, Your Honor.
Robert Sandberg, CR 2136. My docket shows Mr. Sandberg set for pretrial today.
He is, Your Honor. I did file a motion to send its request for discovery. Ready material. The officer, her body cam, took the photographs. Those were not submitted to the DA's office. So the discovery inventory, and I decided working on that. And so we are doing due diligence, but they don't have it yet. He doesn't work anymore, but they found
You said they're photographs.
the photographs he took on a phone of the alleged victims. So, but they're obviously really pretty relevant because they're of the area of the body that's alleged.
Okay. Do you believe that it'd be necessary to hold the pretrial over for those, or we can move forward and then if you saw an issue, court could grant you leave to file a motion to suppress those photographs?
I don't think there's any suppression issues. I just need them. So I think we're fine with just setting it for the 27th or a docket call or. I mean, they don't have it. It's not, they're not reporting.
All right, then the court will set Mr. Sandberg for docket call on May 27th. And if the photographs are not produced or there's no response by then court will consider granting another continuance.
9 a.m. Your Honor.
Yes, 9 a.m. Mr. Sandberg, once you sign and you get the yellow copy, I'm going to order you to report to pretrial release in this room here so that you can sign your conditions of pretrial release and then you'll be free to go.
And I'm sorry, Judge, that's for docket call.
Yes, sir. Docket call 5/27, 9 a.m.
Very good. Sure. May I have excused?
Yes, and then I've ordered him to pretrial release. Mr. White, you ready? Cynthia Kane, CR 20282. I show that Mrs. Kane is set for docket call today, Mr. White.
That's correct, Your Honor. We set to have a plea, we have an offer where we have to come up with some finances prior to being able to pay.
Okay. And also, okay, so we're on docket call today. Okay, so court will set Ms. Kane. How long do you think you may need for her to come up with whatever she needs to come up with?
Not really very long. Probably this up to 27.
Any objection from the state?
No.
All right, court will set Ms. Kane then to enter a plea before the court on May 27th at 9 a.m. In the meantime, Ms. Kane, after you get your yellow copy, I also need you to report to pretrial release, to sign your conditions of pretrial release. Have a good day, Mr. Schmidt. She needs to report to pretrial release and then she'll be free to go. Just go around that way and Joe, can you move that chair right there? It's in the way. Marcus Fowler. CR 2159160 set for docket call.
That's correct, Your Honor. We received a plea bargain this morning that's arguably different than all prior ones. I need to be able to explain this, but I think that if we could have the reset early for 27, that would give the 10 days to allow us to have an opportunity to explain the situation.
What's the offer now as
Well,
compared to before?
one was, the offers before were penitentiary time. Now we're talking about class A. So that stark difference in what we were coming forth ready to make an announcement. And I think that if we could have to the next docket, I can make it set. I think we'd be able to possibly develop.
My only reluctancy is this is the fourth setting for docket call. That would be, we started a docket call in December. We've had one every
I'm
month.
not asking for a full month of this, Your Honor. Like I said, the difference between a penitentiary offer where you just need jerk say no to something that you hear for the first time, saying maybe. And we literally had 30 minutes to do that. We would have had this taken care of, but of course I had a meeting with Ms. Heisel yesterday, but of course she had some COVID problems, COVID shot.
Just for the record.
There's a big difference. There's a big difference in having COVID arm and having COVID.
Judge, Mr. White did come to our office yesterday, visited our office with some information regarding CPS report that is tangentially related to this that we did not previously know. I did just make that offer this morning to him, and so we would be opposed to a reset to April 27th. We've been using May 27th all morning, but my understanding is that they're asking for
I meant to say
April
April 27th.
for potential plea or not.
About April 29th, April 27th, we're already at max capacity. So April 29th would be the next event. It's an evidentiary docket, but April 29th.
I can be here even that.
Okay, we'll set Mr. Fowler then for a final docket call on April 29th, and that day will either be accept and plea that day or reject and get set on the jury selection docket. Mr. Ashmore, are you ready on both your clients? Corey Lee Bates, CR 19-106. All right, Mr. Bates is set for a hearing on his motion to revoke.
Yes, Judge, we're asking the court for, we have the plea offers to TDC, I think we announced it last time. We want to accept that offer. However, we do have a request, and the both of that mother is here to show you that she's expecting the due date is any day. The 20th is, if my memory serves, and we're asking for this to be reset so Corey can help mother bring this bundle of joy into the world and then report back to duty MTR, plead true, and report to the Vincent County Sheriff's Office, carry out the terms of the sentence. So this is really a humanitarian request for, we don't need a docket call. I think we're out of docket calls, but we need some time. We're asking the court to do that. The state supports this request. So if the court can give us 3 weeks, 4 weeks, we really appreciate it, but we'll be done with all of our business and ready to wrap this one up.
I've done this a couple times, and usually this is the next announcement. The baby's here, and I got to take him to what baby well visits, and she needs time, and she can't go back to work, and I got to make money. There's no one to support the baby, and all those things are true. I don't want to hear that in the next, if I reset it today, I don't want to hear, well, the baby's here, we got to take her back, you got to take him or her back to the doctor. And I just know that this is going to happen.
Completely understand that, Judge. We'll prepare to plead true today and ask you to give us a check-in date. We need to do, but and I've talked to my client about not, how bad it would be if you missed a check-in, if we do that.
Yeah, I'm not going to do that, because I've done that too, and it creates more work for the court and the sheriff's office when people don't show. And I'm not saying you wouldn't show, Mr. Bates. I'm just saying past examples have unfortunately set the policies, the future policies. I will give you a reset. I'm just telling you, don't come back and tell me I need more time because the baby's here now, because I'm giving you time to get the baby here. I want you to be there for the birth of your child. I know that's important. It's important for you. Family, it's important for mom. It's going to fall on deaf ears if we come back in a month and it's the same request.
Judge, when I propose that we set it for a contested docket for next month, that would give us a little bit more than a month. And we can resolve it earlier if that's convenient for them, or if not, we will be ready to proceed on contested. We're not resetting it, we would then have the court would have full control during that time. I think it's May, and then we don't have to worry about a separate plea. We can set up a contested docket. Either we plead that day or we are prepared for a contested.
It's a good idea. Let me look here. I'm not seeing my contested day in May. I don't see a contested day in May. How about we just set it for May 25th or 27th? You pick. And I'll just expect Mr. Bates to be a man of his word and take care of business on that day.
May 25th.
All right, Mr. Bates, we'll bring you back on May 25th I want you to report on May 25th at 1:30. I want you to report out to the Van Zandt County Justice Center. Donald Bean, CR 19299. All right, Mr. Bean is set for arraignment today. Have you had a chance to go over the indictment with Mr. Bean, Strasbourg?
No, we haven't, we just need to do it over the court. He's injured his arm and reported to court. He just needs to make an announcement. On the track last time. Hang on. So Judge, on the record, my client has CD9, is identified as names spelled correctly, understands the date and the nature of the allegations against him, and wishes to enter a plea of not guilty at this time and allow me time to work with the state. We do have an initial offer of 4 TDCJ institutional division with a $4,000 fine. We did get that offer today. We have just gotten the file shared with us on the portal within the last few days. We're going through it. So we're just asking this court to set our case for the first available pretrial.
Okay.
Report back at that time.
All right, the court will set Mr. Bean's pretrial for May 25th at 9 a.m. Court will also enter his plea of not guilty in the record for purposes of arraignment.
Hey, Mr. Meehy.
Yes, free to go. So you have this
I think
judgment?
that's it.
Yes, thank you. So you have anything this afternoon?
I don't think so, but I'm gonna go over there.
Okay,
Of course, they.
thank you, sir. Joe Sanchez. This is CR 2362. Yes, ma'am. Thank you. Mr. Sanchez, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you may put your hand down. Mr. Sanchez, are you a United States citizen? Do you read, write, and speak English? And have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Ms. Ann Thompson. Are you pleased with her representation of you? Do you feel like you've had enough time to discuss your case with her and have all of your questions answered? Is there anything about the paperwork that you've read and signed that you do not understand? Ms. Thompson, do you believe Mr. Sanchez to be competent today? And you've explained to him his legal and constitutional rights and also the advantages and disadvantages of a deferred adjudication plea? All right, Mr. Sanchez, the grand jury charged you with a third-degree felony offense of possession of controlled substance in penalty group 2 greater than or equal to 1 gram, but less than 4 grams. A third-degree felony offense carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice, and also a fine not to exceed $10,000. Do you understand that full range of punishment? How that could be applicable to you is if the court approves this deferred adjudication plea today, if there's an allegation that you violate your community supervision and the state files a motion to revoke your community supervision, they could ask the court, upon proving it to the court, to revoke your probation and convict you of this third-degree felony offense and ask the court to assess your punishment anywhere between 2 years and 10 years. Do you understand that? Understanding that, Mr. Sanchez, then how do you plead to the third-degree felony offense of possession of a controlled substance in penalty group 2 greater than or equal to 1 gram but less than 4 grams? And Mr. Sanchez, are you pleading guilty because you are guilty of committing that offense? Has anyone threatened you, forced you, or pressured you to plead guilty to this offense? Court accepts the defendant's plea of guilt at this time. Ms. Thompson, is there any objection to State's Exhibit 1, the stipulation of evidence? All right, State's 1's admitted into evidence, and the court will take judicial notice of Mr. Sanchez's judicial confession. Is there anything further from the state? From the defense? Let's take a moment, Mr. Sanchez, and review the evidence. All right, based on the court's review of the evidence, I find that there is sufficient evidence to convict the defendant of this offense. The court, however, will follow the plea agreement. The court defers a finding of guilt, places the defendant on 5 years community supervision, assesses a $2,500 fine, orders restitution in the amount of $180, court costs in the amount of $290. Court also orders Mr. Sanchez to pay reimbursement fees of $785. Court finds that the state is rejecting and considering 2 unfiled misdemeanor causes, 1 driving while license invalid, and 1 possession of marijuana less than 2 ounces. All right, Mr. Sanchez, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step forward to be fingerprinted with the bailiff. After that time, I want you to report over here to the preacher or to the community supervision officer, and they will give you additional instructions on your probation. Okay? You're welcome. Yes, ma'am. Do you have anything this afternoon? Yes, ma'am. Michael Edward Reisner. Good morning, Ms. Platten.
Morning, Judge.
All right, I've called Mr. Reisner. He's here in the courtroom. And Mr. Reisner can see on our television screen. This is CR 2139-140 State versus Michael Edward Reisner. I show that we are set for a docket call today.
Yes, Your Honor.
And what's the defense announcement?
The state made another offer to us yesterday that I haven't had an opportunity to convey in great detail to Mr. Reisner. I'd like Ms. Reisner to be able to extend that offer on the record so Mr. Reisner could hear it.
And State, will you turn on your microphone?
Your Honor, the new offer in this case is 10 years on a lesser included sexual assault of a child.
That's my understanding of the state's offer, Your Honor. I was going to ask if the court could allow me, I think I have another setting on May 11th. And in this courtroom, there was a case yesterday that you moved to that date. I was going to see if you would allow us to have until that time to decide if we could accept this or not.
State, do you have a position on that?
Your Honor, we're unopposed. I met with the victims of each of these fathers yesterday and made a new offer after that meeting. So I believe that May 11th is reasonably set.
All right, court will set Mr. Reisner then for a final docket call on May 11th at 9 a.m.
Thank you, Judge.
I'm going to fill out a notice of appearance form for Mr. Reisner to sign, and then he'll be free to go. All right, Mr. Reisner, the bailiff's going to bring this form, have you sign there at the X. We'll give you a yellow copy, and then you'll be free to go.
Thank you, Your Honor. I think that's all I have for the court today.
Yes, sir. Thank you. Free to go.
Yeah. Bye.
All right, I believe Mr. If you're Mr. Sanders' client, raise your hand. Okay, he is running late. He's going to be here, but I believe he's wrapping up business in another court. And let's see who else we have. The rest of you must be Mr. White, correct? I believe all of these are Mr. Harrison's clients. I don't believe any of them are Mr. Fowles' clients, and they filed motion of continuance in every one of them.
Okay, I just want to make sure that they were all.
Mhm.
So Mr. Tapper.
Yes, they're all May 25th. I had them all signed. Mr. Tapper just signed a notice of resetting to 5/25, and he was excused. And then we had pretrial release conditions for Devin Key and Sean Koontz.
Yes.
I don't know yet. We still have an hour. Is Mr. McLaren here? He and Mr. Pappas are scheduled at 11, and then Mr. Weiner and Mr. Howell are scheduled at 11. So, all right, court's going to stand in recess until we have some announcements from Mr. White and Mr. Sanders. So you're free on recess. You're free to move about. And then whenever your attorney gets here, meet with them and we'll get back on the docket. All right, Ms. Tompkins. All right, Ms. Tompkins. You'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. All right, Ms. Tompkins, I believe, is currently on the court's jury trial docket. Is that correct?
That's correct, Your Honor.
And you're asking the court to allow Ms. Tompkins to enter a plea agreement with the state today?
I am, Your Honor.
Ms. Tompkins, are you a United States citizen? Do you read, write, and speak English? And have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you? You feel like you understood everything that you have read and signed? Is there anything that you do not understand? Mr. White, do you believe your client to be competent today?
Your Honor, I believe that Ms. Tompkins is competent. She understands the procedure for opinion against her here. Note to the court that she has executed some waivers. I believe she executed those waivers knowingly, intelligently, voluntarily. Will the court goes along with the plea agreement, should be placed on deferred adjudication. Represent to the court that I have explained to Ms. Tompkins the advantages and disadvantages there in such an agreement. Most notably that if she completes it, the case will be dismissed. If she violates any further condition, the court will have this entire punishment, which in this case would be up to a year in the county jail and for time to exceed 4,000.
Thank you, Mr. White. All right, Ms. Tompkins. So my understanding of the plea agreement is that you're going to plead guilty to this offense in exchange for the state's recommendation that you be placed on 2 years deferred community supervision, restitution in the amount of $8,300 plus court costs and reimbursement fees. Is that your understanding of the plea agreement? And that's what you're wanting the court to approve today? Ms. Tompkins, the range of punishment for a state jail felony under section 1244B of the Texas Penal Code is confinement in the county jail for a period not to exceed 365 days and a fine not to exceed $4,000. Do you understand that range of punishment? If the court approves this agreement today and you subsequently violate the agreement, the state could file a motion, bring you back to court, and if they prove that you violated any of the terms and conditions of your probation, the court could revoke your community supervision, find you guilty of this offense, and place you in jail up to 365 days. You understand that? All right, understanding those things, Ms. Tompkins, then how do you plead to theft of property, $2,500 to $30,000 under section 1244B? Guilty? Are you pleading guilty because you are guilty of committing that offense? Has anyone threatened or forced or pressured you to plead guilty to this offense? All right, the court will accept Ms. Tompkins' plea of guilt at this time. Mr. White, any objection to states one?
No, sir, we have no objection.
States one is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? Yes, ma'am. Is there victim compliance in this case at all?
There is this one.
Victim supportive of the plea?
I don't,
So I guess my question is if I approve this plea agreement, I'm not gonna have an angry victim standing at the door of my office wanting to know why I approved the plea agreement?
No, Your Honor, I have spoken to Jason before on this, and like I said, notified them, of the agreement. I would say, not what they, before the beginning of this, that they are looking for, receiving a plea.
And can you,
Just checking, Your Honor, to make sure we do not have maybe some tax taken on file.
again, the evidence is quite voluminous here. Can you just give me a brief summary of this case?
Yes, Your Honor, Ms. Thompson was working, for a husband and wife who had a business on Amazon where they would buy, clothing products and, personal beauty health products in bulk and then resell those on Amazon. Ms. Tompkins was in charge of inventorying those things and posting them online, shipping them, those kinds of, duties. It became apparent to the, husband, special couple, that some of the things, that they believe should be in inventory were not. And Your Honor, the, victim in this case saw Ms. Tompkins' Facebook page where he believed that some of the items she was selling on the Facebook page were, the same items that he believed should have been in his inventory, and she did not have permission to take them according to them.
Go ahead.
Court, there was motion to suppress filed in this case, the court granted motion to suppress the search warrant. After we started discussions on that, we came to the determination that the amount of restitution is now $100, and I'm not saying we agree with that amount. And I think that both parties, while I understand that the victim may not agree with it, I think the lawyers in this matter come to the conclusion that's the most correct amount that it would be, especially the appropriate.
Mr. White. Okay, court's going to follow the recommendation of the state agreement. Court's going to find that there is sufficient evidence to convict Ms. Tompkins of this offense. Court, however, will defer a finding of guilt, place Ms. Tompkins on 2 years deferred community supervision under section 1244B of the Texas Penal Code. Court assesses court costs in the amount of $270, reimbursement fees of $35. Court orders restitution in the amount of $8,300 to be paid to Mr. Darren Smith as indicated on the judgment. So Ms. Tompkins, you're going to have a little under 2 years to pay off all the restitution that you owe while also maintaining and paying your supervision fees, drug testing fees. And so it's going to be quite an amount that you're obligated to pay. Are you going to be able to take care of this business? All right, Ms. Tompkins, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step forward here to be fingerprinted with the bailiff. After that, I want you to report to the probation department over here through these doors. Yeah, I know it's the camera. I can't do anything about it. It cycles in and out. So the only thing that we can do is perhaps unplug. penalty group 2, greater than or equal to 4 grams, but less than 400 grams for a period of 2 years or 24 months. Is that correct? Do you understand that by entering into this contract, there's some very important rights that you would be giving up? And you've spoken to Mr. White about all of the provisions in this contract, and do you understand everything that you've read and signed? Are you pleased with Mr. White's representation of you? Mr. White, you have explained to Mr. Smith the important rights contained here in this contract with regards to the waiver of jury trial, waiver of speedy trial, the limited waiver of expunction, and some of the contract stipulations regarding the admissibility of evidence if it goes to trial.
Your Honor, I explained those things to Mr. Smith. I have no doubt that he absolutely understands them. He understands what the board or the agreement requires him to do.
Right, Mr. Smith, do you understand that you have an absolute right to have your case tried to a jury of your peers? You understand that during that process, you would have the right to cross-examine and confront the state's witnesses and their evidence? Do you understand that by entering this contract, you would be waiving that right? And are you waiving that right intentionally, knowingly, and voluntarily of your own free will? All right, the court will approve the waiver of jury trial in open court, and we'll find that it has been joined by the attorney for the defendant and the attorney for the state. All right, the court's going to approve the pretrial intervention contract between Mr. Smith and the state. All right, Mr. Smith, you're being given a golden opportunity here to have this case dismissed and most of your records expunged if you successfully complete it. You're also bearing the risk that if you do not, you'll be placed back on the court's docket and you will have waived your right to a jury trial and you will have stipulated to the evidence that's involved in this contract. All right, so you've got a great opportunity, but you also have an opportunity to put yourself in a worse position if you don't comply with the contract. You understand? All right, so I expect when you get on this pretrial intervention supervision that you're going to take it seriously. You're going to do what you're supposed to do. You understand? If you don't, what level is this offense? This is a second-degree felony. Is that correct?
Correct, Your Honor.
So if you do not take care of business and the state puts you to trial, you're looking at a range of punishment from 2 years to 20 years and a $10,000 fine. It's pretty heavy. Okay. All right, Mr. Smith, I'm going to hereby remand you to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the pretrial intervention contract. I'm going to have you step forward and meet with Ms. Burns. Janice Alcalan. Cause numbers 2018-433, 2019-140, CR 2376. And Mr. White, before we proceed, remind me, my docket indicates that the 2 misdemeanor cases were officially transferred from Judge Winter's court to my court, correct?
They were, Your Honor.
Okay.
We're just set for
Okay. Do you want, are you available on May 27th or May 25th? I can have you come on the evidentiary day, April 29th. All right, we'll set Miss Alcaland then for plea on April 29th at 9 a.m.
Is this hotline for
Yes, free to go. Joshua Brown. If you'll come to the middle podium. CR 2379.
Your Honor, I talked with Mr. Woodblock on this. We filed a motion for discovery regarding some
The blood
lab
line.
evidence. I don't believe the state received that back yet.
Judge, we requested that from the DPS lab, we have not yet received that. I will check again this afternoon. Or see where we are on that and then hopefully hurry that up.
All right, we'll set Mr. Brown for an additional status on the blood lab discovery on May. Are you here on the 25th already, Mr. White? Or would you rather the 27th?
It doesn't matter, whichever one. Clear the document.
Let's go May 27th.
Mr. Brown, for you.
Free to go. We'll see you back on May 27th. James Ethan Fields, 2020-607, pretrial.
Your Honor, we're not gonna have anything that's on that.
Is it here because he has another case?
No, sir. Mr. Judge Winters may transfer.
All right, we'll set Mr. Fields then for docket call on May 27th at 9 a.m. Free to go. Melba Kennedy. This is cause number CR 1959, CR 2171, CR 2257. Show that we're set for pretrial in the CR 20 cases and MTA on the CR 19 case.
Your Honor, we move that over to docket call. I think we're all standing discovery order. I believe we just want to should have received everything for the date.
All right, the court will set Ms. Kennedy then for docket call on May 27th and hearing on her MTA on May 27th. Ms. Kennedy, I'm going to order you to report to probation today. I show that you haven't reported since the end of December. Is that correct?
Yes, I was under the understanding
Well, that'd be an incorrect understanding. You're still on probation. You're still on probation. So I believe that Mr. White would want you to stay in compliance and report and be drug-free and all these things so that he can help be of help to you on your other cases. So you're still on probation. You're still under the orders of this court, still ordered to report, to pay, to drug test. So I'm gonna order you over there today. Yeah, I think I told him we could go. Hang on, is it Brown? Trying to see. Who is his lawyer? Yeah, just come over here and see Officer Ventura and then you just send her to her officer if you want. Mr. Brown, Mr. Brown. Yeah, I think I said. Kennedy. Yes, Mr. Brown, you're free to go. Mr. Weiner, are you ready?
Yes, Your Honor.
Jacob David Howell, CR 28-3. All right, Mr. Howell set for docket call today.
Yes, Your Honor. I've spoken with the state pretty extensively about Mr. Howell's case. This is his second appearance since being released from the hospital from an episode that we weren't actually sure he was going to live through. He has recently had a speeding tube removed and still having some related health issues. These issues don't really impact guilt innocence, but I think we kind of agree that they impact from a punishment standpoint. I'm continuing to gather documentation of the medical records. The recent ones, I have prior medical records. I'm going to do the same. Once I have the most recent medical records, I'm sitting down and seeing if we can resolve the case.
State.
Judge, state would agree with everything Mr. Weiner said, plan to sit down. Like he said, I think we're kind of at it, just trying to figure out what the appropriate punishment is in light of Mr. Howell's recent hospitalization.
Okay. I'll set him for a final docket call on May 27th. That'd be at 9 a.m.
Yes, Your Honor. That should give us plenty of time to make a final decision on which way we're going with the case.
Yes, free to go. Is David McLaren here? Have you seen your attorney, Mr. Pappas? Since when? Night before last? Did he tell you he was planning on being here? Via Zoom? Oh, there he is. Okay, I guess he didn't tell my office that he was going to appear via Zoom, so let me bring him in. Mr. Pappas, can you hear me?
I can. Can you hear me, Your Honor?
I can. Yes, sir. Would you mind putting a jacket on for me since we're in court?
I apologize, Your Honor. I left my jacket down in the car. I can go down and get it and log back in.
No, I'm gonna let you go this time, but next time, if you'll just, every time you appear in court, I'll need a jacket and a tie.
I
So
apologize, Your Honor. I'll make sure that I take care of that next time.
I appreciate that. All right, this is cause number CR 2263, State versus David Wayne McLaren. We're set for arraignment. Have you had a chance to review the indictment with your client?
Only briefly, Your Honor. I was recently retained, and I've gone over it generally with him. And he's prepared for purposes of today to enter a plea of not guilty, waive reading of the indictment, and waive additional formal arraignment.
Is his name spelled correctly?
It is, Your Honor.
All right, court will enter Mr. McLaren's plea of not guilty into the record, and we'll set Mr. McLaren for pre-trial. Are you available on May 27th?
I am, Your Honor.
All right, we'll set that for May 27th. Do you want, I'd set it at 9 a.m. unless you have any scheduling conflicts.
No, I was behind because I was in the hospital in January, but we're knocking it out, and I think 9 is fine, Your Honor.
Okay, then we'll set him for 9 o'clock. I am going to order your client to sign his conditions of pretrial release today.
Okay,
So once we're done here, I'm gonna have him report to the pretrial release officer, and then he'll have a copy of that.
super.
And then I'll give him a copy of this appearance and announcement form, and then he'll be free to go.
Great. Thank you very much, Judge. And I apologize about the code. I'll take care of that.
It's okay. And next time, if you'll let my office know that, oh, you did, okay. I wasn't aware that you were appearing Zoom today, so I wasn't looking for you on Zoom, but we'll make sure we have our docket notated next time.
Yeah, I apologize. We tried to let them know, because I was stuck down in Johnson County at 9. So we called yesterday to let them know that.
Okay, and I believe the state wants to make some kind of announcement.
Judge, if Mr. Paulus can contact our office to get set up on the online portal, if it's not here, so he's done that at this point. That way we can get the discovery for Mr. Craig's open up and set it.
Did you hear that, Mr. Travis?
Did, and I've of course been there before, and we'll get it taken care of.
All righty. All right, we'll see you back on May 27th then.
Great. Am I excused, Your Honor?
Yeah, yes, sir. Excuse. Have a great day.
All right. Thank you.
You're welcome.
Judge, may I have you excused as well?
Yes, thank you, Mr. Warren.
Thank you.
All right, Mr. McLaren, I'm gonna have the bailiff bring this to you. You're gonna sign there on the X, and it's got the reset date for May 27th at 9 a.m. We'll give you a copy of that. And then after that, just come over here and you're gonna meet with my pretrial release officer. All right, Mr. Davis, if you'll raise your right hand, I'm going to place you on oath. Mr. Davis, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you can put your hand down. Mr. Davis, are you a United States citizen? And you read, write, and speak English? Ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Jeff Sanders. Are you pleased with his representation? You feel like you've had enough time to talk about your case with him and have all your questions answered? Anything about this plea agreement that you do not understand? All right, Mr. Sanders, you believe your client to be competent today?
Yes, Your Honor.
And you've explained to him his legal and constitutional rights and the advantages and disadvantages of a deferred plea?
Yes, Your Honor, we have discussed the good points and the bad points.
Mr. Davis, you're charged by indictment with a state jail felony offense of theft of property greater than or equal to $2,500, but less than $30,000. That carries a range of punishment of confinement in the state jail division of TDC for not less than 6 months or more than 2 years, and a fine not to exceed $10,000. That means if the court approves this plea today, places you on deferred community supervision. If later you violate your community supervision, the state could file a motion, and if they prove to the court that you violated, the court could revoke your community supervision, convict you of this offense, and sentence you to any amount of time up to 2 years in prison. You understand that? And you want the court to approve this plea agreement today? Understanding that those things, Mr. Davis, how do you plead to this state jail felony offense? Mr. Davis, are you pleading guilty because you are guilty of this offense? Has anyone threatened or forced or pressured you to plead guilty? All right, the court accepts the defendant's plea of guilt. Mr. Sanders, any objection to states one?
No.
States one is admitted into evidence. Court takes judicial notice of the defendant's judicial confession. Anything from the state?
No, Your Honor.
From the defense?
No.
All right, Mr. Davis, the court finds that there is sufficient evidence to convict you of this offense. However, the court will follow the agreement. Court defers a finding of guilt in your matter, places you on 5 years community supervision, orders you to pay restitution of $3,500 to the individuals and agencies indicated on the judgment. Court also assesses court costs of $290, orders you to pay reimbursement fee of $535. Mr. Davis, I'm going to ask that you come forward to be fingerprinted with the bailiff, after which time I want you to meet with Officer Maturi here for additional information about your probation. Thanks, sir. Who's your next plea, Mr. Sanders? Mr. Wright. Thank you. This is cause number CR 18344, State versus Devontae Trayvon Wright. Mr. Wright, will you raise your right hand so I can place you on oath? Mr. Wright, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Mr. Wright, are you a United States citizen? And you do read, write, and speak English? And have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Jeff Sanders. Are you pleased with his representation of you? Like you've had enough time to discuss your case with him and have all your questions answered? Anything about the plea agreement that you do not understand? Mr. Sanders, do you believe Mr. Wright to be competent today?
Yes.
And you've explained to him his legal and constitutional rights.
Yes.
If the court approves the plea agreement today, is Mr. Wright making any payments towards his fines or court costs or reimbursement fees?
Judge, he's not able to today. Or maybe, yeah, so it's fair.
Does he understand that if he fails to set up a payment plan and follow it, the court will issue a warrant for his arrest?
Yes.
All right. Mr. Wright, you are charged by indictment with theft of a firearm or state jail felony. However, the plea agreement appears to be that you would plead guilty to a Class A misdemeanor offense of unlawful carrying of a weapon, with punishment being 2 days confinement in the county jail with credit for time served, a $2,500 fine, reimbursement fees of $535, and court costs of $270. Is that your understanding of the plea agreement? And you understand that if you do not pay the things that you owe, that the court will issue a warrant for your arrest and you'll be brought back to Van Zandt County? Understanding those things, Mr. Wright, how do you plead to the Class A misdemeanor offense of unlawful carrying of a weapon?
Yeah, I'm good to.
Okay, and you understand that the range of punishment for a Class A misdemeanor offense is confinement in the county jail for up to 365 days? All right, Mr. Sanders, any objection to states one?
No.
It's, states one is admitted into evidence. Mr. Wright, has anyone threatened or forced or pressured you to plead guilty? All right, the court accepts the defendant's plea of guilt and also takes notice of his judicial confession. Anything further from the state, from the defense? All right, based on the court's review of the evidence, I find that there is sufficient evidence to convict Mr. Wright of this offense. Court hereby convicts him of Class A misdemeanor unlawful carrying of a weapon. Court will assess his punishment at 2 days confinement in the Van Zandt County Jail. The court will issue Mr. Wright 2 days credit for time that he has spent in jail on this cause. Court also assesses fine in the amount of $2,500, court cost of $270, and orders him to pay $535 reimbursement to Van Zandt County. Mr. Wright, I'm going to have you step forward to meet with my bailiff here to be fingerprinted, after which time I'm going to ask that you report down the hallway and meet with Miss Bonnie LaPratt to set up a payment for your fines and court costs and reimbursement fee. Need more cards for Bonnie. Do you have cards for Bonnie? Yeah. Mr. Wright, lunchtime, Ms. LaPratt's probably gone to lunch. I'm gonna give you a card here. That's her number. Make sure you contact her and set up that payment plan. Travis Skinner, CR 2226, CR 2065. Set for docket call today, Mr. Sanders.
Yes, Your Honor, that's correct. The judge, we're asking if we could reset for one more docket call. Talking with the state recently, some of the evidence that we've been waiting on last time, I think had come back in terms of toxicology report. But I think the blood is being resubmitted. I mean, this title.
Sure. Judge, we were waiting on the toxicology report. The alcohol screen came back, but it has been resubmitted for drug analysis. I've been told by the lab that it has been assigned to an animal anomalous. However, that analysis had not been performed such that we have results back. Especially based on the facts as we know them at this point and the result of the alcohol screen. State is going to request an additional docket call and not set this for trial until we have the results of that toxicology screen back. I think it would be both highly relevant to the case and helpful to both Mr. Sanders and I in potential resolution.
All right, the court's going to set Mr. Skinner then for additional docket call on May 27th, at 9 a.m. All right, once you get your yellow copy, you'll be free to go. Ms. Bailey? CR 2378, Say versus Megan Bailey. Set for docket call.
And Your Honor, with Ms. Bailey's case, we do have all the discovery and an offer, and we've done that for a little bit more time than work on the case and talk with Ms. Bailey, some more and talk to the state, see if we can get this resolved, that we need to have it set for trial.
Any objection from the state? All right, the court sets Ms. Bailey then for an additional docket call on May 27th at 9 a.m. Once you have your yellow copy, you're free to go. Mr. Sanders, do we have any information on Jimmy Gibson? At one point, he was in Dallas County custody, but I don't think so any longer.
TBC facility.
Stayed online yesterday with Dallas County for about 30 minutes. And I thought,
He said he may be in TDC.
Douglas Gibson is currently bird units of TC 61. Yeah. That's about right.
Yes, I'm a little stuff. It's good, he's written to me, but he didn't say where, he just said his case was involved in Dallas County, but didn't say where he was.
It appears, according to TDCJ website, he got 3 years in Dallas County on January 15. But aggravated assault. 3 years is projected to release 2023.
Guess that'd be a decision for the state on whether you want to bench warrant it or.
Yes, sir. Let me, if we could reset it for the status of the order. I would pick Mr. Murray. We will pick this. We'll obviously include Mr. Sanders.
We'll set this for. Let's set this for Thursday, June 3rd. Set off a little further for status, TDC status.
Judge, we will have to explain.
Thank you, sir.
And Judge, just so the board is aware, it does show that you have an active warrant on this for our county. So in the event that we get released through TDC, I'm not sure what the potential release date would be. We theoretically should have a hold on it.
So, His projected release date is February. Eligibility is 2022, so. 8 months.
Okay. We'll set him in June and then let y'all visit about that. All right, I believe that concludes the morning docket. All right, court's gonna stand in recess until 1:30.
Am I too late, Steve, Judge?